Good morning, Mr. Asanga.
Morning, Your Honor.
Sir, you are wanted out of, you say Fayette?
Yes, Your Honor, Kentucky.
From Kentucky for theft by deception of up to $10,000. Your lawyer has asked for me to set you a bond, and I'm going to tell you now that we don't set many bond in fugitive cases because you are an inherent flight risk, right? You're wanted from a different state, and we're putting a lot of trust that you're actually going to go back. You're old enough to know that actions have consequences, right? I'm going to set you a bond today because they're not opposed to it. She's asked for a $1,500 bond. The state's asking for a $5,000 bond. I'll set your bond at $2,500. Because it's a fugitive case, typically you'll have to make all of it. They don't usually do the 10% because, you're a flight risk. So the thing that you need to understand also is that I'm only going to do this one time. I'm not going to do this again. I will give you one bond. And what we do is we give you 2 weeks from the date of your release to go turn yourself into Kentucky. If you do, and you get the proof to Ms. Morgan here, they'll dismiss this fugitive case against you. If you fail to go, you got to know that there's a consequence, and the consequence is huge because I will revoke the $2,500 bond. I'm going to set it at 0, and I'm going to issue a nationwide warrant for your arrest, and I'm not going to do this again. I'll get you eventually, and this time I'm going to hold you until Kentucky comes and gets you. Do you understand?
I understand, yes, Your Honor, but the only problem I might have is with the full amount, paying the full.
This is not a negotiation, right? I'm going to tell you that $2,500 is a very low bond for a fugitive case as it is. So I can tell you probably on one hand how many times I've set a bond at that amount or even lower. So the other thing you need to understand, Mr. Asanga, is that for you to post bond, you have to withdraw any waivers that you've made. Did he waive? Ms. Morgan, did he waive? It's not. Okay, so it's a non-issue then. I don't need you to make a decision now what you want to do. If you want to waive extradition, we give Kentucky 14 days to come get you. If they don't come get you within that time, Harris County releases you. I'll give you time to talk to Ms. Morgan to tell us what you want to do, whether you want to waive, whether you want to try to make bond. It's up to you.
I'd like to make a bond.
Okay, so I guess
The reset then, last date is the 30th. Well, the 30th would be court date, but the morning of, we check if we haven't heard back first.
what I would suggest is probably not setting it off 2 weeks, just in case that there's an issue. I mean, if you definitively know someone's going to post a bond, then go for the 2 week, But if you've spoken to family and they're having trouble, then just do it, right, so that we didn't sit
I
there for
might
2
be out of
weeks.
town that week, Your Honor, so I would approach sooner.
I Zoom. That's why I have it, so you can always, we've had people come in bathing suits, So, okay, all right. Good luck to you, sir.
Thank you,
Your
Judge.
Honor.
You're on my approach?
Yeah.
Judge, I'm approaching on Christopher Fox. He cannot be benched.
Are you?
Just getting over a
You
cold.
good? I just saw Mr. Coyne a couple days ago.
Really?
Yeah, such a great guy. I really like him.
Yes.
Okay.
You guys, are you talking? Yeah, okay, I get
This is a walkthrough. She has an open case upstairs that's also in warrant status. Frank has been talking with Judge Nelson in the
Is this, may I have the case number, please?
252 1200.
Okay.
So because she has a felony warrant, I'm not going to release her. We'll do PC now, and I'm going to keep her, and then Frank's going to run up to the 482nd to try to get her a bond set there.
It looks like probable cause was found on July 25th, Judge.
I'd like to know, but I don't know. All I know is that she's charged with assault. She also has an injury to a child that looks like they're out of the same transaction.
Yes, Judge.
You're facing up to a year in jail and or a $4,000 fine in the assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you then.
On June 24, 2024, off with multiple complainants, and one of the complainant's mother, Dr. Clinton, this case investigated an assault that occurred in an apartment complex. Complaint stated that on Wednesday, June 5th, 2024, this complainant, that's sort of part A, oh, there, the, the complaint that they met, the brother is a complainant in this offense who's 15, and his friends were walking their dog, encountered a juvenile male, who's the son of the defendant, over problems they had in school. Juvenile male's mother, the defendant, exited her apartment unit, started to confront the complainant and followed co-complainant and this complainant to a fence. The other complainant felt the need to defend himself due to the now defendant being close to him, but he did not assault the defendant. Defendant pepper sprayed that defendant and that complainant, this complainant, attempting to get her to stop by swinging at her. Defendant also pepper sprayed, pepper sprayed this complainant, but only hit one of his arm. The other complainant felt pain from being pepper sprayed by the now defendant, and the first complainant, the mother of the other complainant, wanted to pursue charges. A witness who lived in the apartment complex corroborated the statements of all the complainants.
So who are the complainants now?
So
Relation?
it is brother complainants and their mom, who is another complainant, but I don't know if they.
So it's familial.
I think it's, no, I think it's the two boys, the complainants, but one of them's 15 and older.
So they wrote it as complainants, but it only accepted charges. So I guess the way they verbalized it initially to the officers, the way they wrote it down was complainant 1, 2, and 3, or
Okay.
complainant 2's mother, complainant 1. So formally, in terms of the charges, there is the complainant upstairs for injury of child, and then this complainant is 15, which is why it's right above the felony level. But they wrote the mother as complainant, I guess, to the surface.
Ours is
But ours, the complainant here is a 15-year-old.
no familial relation.
No.
No, it's just that their brothers and friends encountered the juvenile male, the son of the now defendant, over problems they had in school. So it seems like there was a schoolmate issue.
Okay. Ma'am, did you want to say something? I'm sorry.
I mean, I know that we'll fight the facts in the future, but she takes care of 3 children. The son that they're talking about, the son's 12 years old. Looks like there was some argument between these kids, and just to make her point of view, she was trying to speak with the complaining witness's mother regarding this whole situation. Looks like it got out of hand. I do have a picture from the defendant regarding an injury that she received from a busted lip of that day from the juvenile. Moving forward, I would like to set a bond, at least at the minimum of $1,000, and it'd be a PR bond.
State of Texas.
Judge, I just need seconds. I was trying to look up something else that wasn't popping up. Your Honor, state requests that reasonable bail be set because this is not the only complainant involved. Obviously, there's the felony as well, and the fact that she has been charged prior for a disorderly conduct with a deadly weapon, assault family member.
The injury to a child, it's what, 14, right? 14 and under?
Yes, and the other complainant was 12. So that's why there's a felony and a misdemeanor, and the fact that they're both involved and there was a witness is that allegation still resolved. So state requests reasonable bail be set at $7,500.
Family violence was dismissed, Judge. The only conviction I see is theft.
Yeah, I mean, I see 2 dismissed, I see dismissed it orderly. Do you have any like out of state or anything else?
I don't believe it's,
Okay, well,
it's not enough for me to impact my,
right.
oh no, it's down here. Never mind, sorry. They're all in, but
So it looks like the only possible conviction that I see is a theft from '09.
yes, Judge.
And the other 2 cases,
The only bond forfeiture is very.
okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm going to set your bond at $1,000 now. We'll give you a PR bond now, but I'm not going to play this game. I'm going to protect everyone in my community at all costs. I don't care who you are, where you come from, doesn't matter. You understand? As part of your bond conditions, you're not to have any contact with the complaining witness in this case and not to be in possession of any weapons as well. Weapons is a very loose term. So if you have any questions, talk to Frank, because no weapons whatsoever. I'm also ordering you not to go where they live or where they work as well, man.
I do have a concern about that because do they live in the same apartment complex or is it a different?
I think it was the children that are schoolmates, so I don't think there's otherwise, but not that I could find. I'll take a closer.
They were
look.
just roaming around.
Her head, so I don't believe that'll be an issue.
And so you're okay. Day, I'm going to attach you to this as well. I'm going to go ahead and email Judge Nelson.
It's the ADA on record. I'm just helping out since we're shorthanded and but I'm not opposed.
Who said that she's not being there, oh, you've been out, all these times, just stay right there. Oh, that's not the reason.
Yeah, I can take over. Sure.
It's a fugitive case.
Oh, it's fugitive. Then I have to stay.
Frank, what is your email address?
Excuse me?
Your email address
MORFIN law.
at Gmail?
That's correct, yes.
Okay, I have emailed you guys and I CC'd you guys. I've also talked to her. Would you please take a seat in the jury box? Do not leave until we have you sign bond conditions and then until Frank gets back to talk about the bond. Okay?
Thank you, Judge.
No, ma'am. Jury box. Hi, bless.
Please.
Okay.
Not one. This one is.
So did you see the PR bond? You need a cause number?
Ventura Lopez?
Do you want to do them one at a time? Sorry, I should have asked you. What? Do you want to do them one at a time? Yeah, let's do them at the same time.
Same time.
No weapons? Yes. And then I'll have them, Day, do you mind getting the address so we can give it to them so that she knows? And no, so no contact, no weapons, no going to where they live, where they work. Bond set at 1,000, PR bond granted.
Pueden tomar asiento y lo nombramos en un segundo. No muero.
Is one of them yours? Let's do it together.
You ready?
Yeah, come on, come on.
Oh,
Bring it.
okay. I didn't know.
It's deficient. Take your time.
Y van a contestar a voz alta, no puedo interpretar.
We're
gestos.
Mr. Gil Rodriguez
Rodriguez?
and you
Yes.
are Mr.
¿Usted
Ventura.
es Ventura? Yes.
Both of you
Los
have
dos
picked
de
up
ustedes
criminal
tienen
cases.
delitos criminales.
Both of you have
Los
worked
dos
out agreements
han
with
llegado
the
a un
state of
acuerdo con el
Texas.
estado de Texas.
You need to understand that the agreements that you guys are working out today will reflect as convictions on your record.
Sus convicciones
Once you plead guilty, there's no turning back. It will go on your record
van a estar,
and it will be there for the rest of your
van a
life.
estar allí para todo.
You give up many valuable rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. And like I told you earlier,
Las leyes federales, como les
once
dije,
you plead,
no, al
it's there
declararse,
forever. It's even there after you die. You can never take it off. Mr. Gil Rodriguez, you are charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine.
$1,000
The agreement you've worked is 7 days in jail, credit for the 7 days that you've done. Is this how you understand it?
I understand guilty.
All right, I'm going to find you guilty. I will follow the agreement, send you to it. I'm going to tell you now
Voy a
that
decir ahorita,
any more cases you pick up, you will be facing a minimum of 90 days in jail. No more proverbial slaps on the wrist.
no los vamos a dar.
Mr. Ventura Lopez, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine, and you've worked out an agreement where they're offering you 6 days in jail with credit for the 2 that you've done. Understand, by pleading guilty to this offense from now on, you will be facing a minimum of 30 days in jail.
30.
You understand?
Yes.
This is what you want to
Eso es
do.
lo que usted. Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
No culpable. Guilty.
I'm going to find you guilty, sentence you to the agreement.
¿Al acuerdo?
I'm going to tell you now, anytime you get pulled over, officers will look at your record. They're going to see that you have a prior DWI. If they come up to your car, they smell alcohol on you, it's probably not going to go well.
No le va a ir.
If I were you, for the rest of your life, if you want to get lit, don't get into a car
No se meta en otro.
because it's a humongous gamble. I'm suspending your license for 90 days. Do not drive until you get a license.
Tenga una licencia de conducir.
Yeah, you're appointed on the case?
I am, Judge.
Okay. I'm going to tell you one more thing, that DWI is big business in Texas. There is a $3,000 surcharge that normally we would tack onto this. On a second DWI, it is a $6,000 surcharge that you can look forward to on another one. So be careful. Don't come back.
Y no
All
regrese.
right.
Thank you, Judge.
Yeah. All right. Good luck, guys.
Are you waiving the surcharge? Oh, thank you,
No le van a
Judge.
cobrar los 3,000. ¿Tiene gracias?
Do I know you?
Thank you.
I mean,
Le van a cobrar los $3,000.
gentlemen, that way.
Oh, no, we'll hear back from Stacy. She went in the holdover.
When you're on there, what do you want? Oh.
So he said it at,
2,500.
Yes.
Okay.
Yeah, that's fine.
let me make it. Good morning, ma'am.
Morning.
Shh. You are wanted out of the state of
Pacific. For a burglary, Your Honor.
for a burglary charge. Your lawyer is asking me to set you a bond. I don't know. You know, one of the main things are you a danger to my community? Because if you are, it's just not going to happen. I'm going to do everything in my power to protect my community at all costs. You know, I have a lot of people that tell me, you know, little bunnies jumping in the woods, that's who they are. But when I look on paper, they're a completely different person. Mr. Kim, would you mind telling us about Ms. Hale, please?
Yes, Your Honor. She's currently also being held in the 182nd for second-degree level of possession of a controlled substance. She was recently convicted in Galveston County for a deadly conduct charge that was initially pled as an aggravated assault with a deadly weapon, along with a burglary habitation that was dismissed, presumably with a plea deal. She was also previously charged with possession of a controlled substance that was dismissed earlier last year as well. She was previously a fugitive, charged as a fugitive in the 90s, along with a few other charges from Mississippi, 2 charges of larceny, 1 charge of grand larceny, and obviously these offenses.
Yeah, I don't, it's too much baggage, man, you know, and especially you also telling me that this case is over a year old.
For the warrant, that one was issued out on January 10th, 2024, Judge. So it's been 1 year.
Do we know if she knew about it?
That I wouldn't be able to say. I don't know if it's an FTA, Judge. I can find out, but I don't know the answer to that one. It typically says, it just doesn't say.
Here's the deal. If I were to set you a bond, you would have to make, I think you would have to make all of it. It's not something where you can pay the customary 10% because you're an inherent flight risk and you have a prior fugitive case as well. You know, I don't think, I'm not going to set you a bond, man. You just got way too much baggage. You have a prior failure to appear. This case is a year old. You've got a second-degree felony. Is it with intent to deliver?
No, Your Honor, it's just the amount, 4 to
Yeah,
200.
it's just too much, ma'am. I'm sorry. So the deal is this, is that you have 2 choices now. You can waive extradition, which in this case, normally what happens is we give the other jurisdiction 14 days to come get you. And if they don't come get you, Harris County releases the hold. But for that to happen, you have to make bond on the felony case. Because you have not made bond on that case there, it's kind of in a holding pattern until you either take care of that case or you post bond on that case. If you post bond on it, that will get the 14 days to start kicking. Okay?
She's already signed a waiver, Judge.
Oh, she's waiting.
Signed it at the Met
Oh, okay.
already, Judge.
Got it. Okay. But just to give you information, I don't know how much you know or not, but right now we're basically in a holding pattern anyways, just because you've not made bond on that case. Okay? If you don't understand, I can have Shelby tell you more about it so that you can get a good grasp on what everything is. But understand it's just too much baggage. Okay, all right.
Thank you, Your Honor.
Thank you.